Their patent sucks, so why don't you invalidate it? Part 2. My name is Steve Hansen. I've been a practicing patent attorney for over 25 years. Not only do I write patents, but I tear apart other people's patents in litigation. If you like this content, please like, follow, and share. This is the second of a multi-part video series on invalidating somebody's patent and the different procedures for doing that. This one concerns ex parte reexamination. It is the cheapest and weakest mechanism that's available to you to invalidate somebody else's patent. What you do is you submit a request in which you identify substantial new questions of patentability for every one of the claims that you want to challenge, and that's typically done by identifying prior art the Patent Office was not aware of during the initial examination, but it can also be based on prior art they were aware of if you believe that they misunderstood it. So you submit this request, you identify those patentability questions, and if the Patent Office agrees with you, then they re-examine the patent. But at that point, your involvement as the requester stops. You don't get to respond to what the patent owner says, even if you think it's BS. And so that is one serious limitation on ex parte reexamination. Another one concerns the types of evidence that can be considered in an ex parte reexamination. It is limited to prior art invalidity, so you can't base it on insufficient written description, lack of enablement, indefiniteness. Can't base it on any of that stuff. It's limited to prior art patentability, and the forms of prior art it's limited to are patents and printed publications. So you can't base it on products that were on sale or products that were in public use. It has to be this sort of documentary prior art. And one thing that can happen, unfortunately, is the patent examiner can review what you've submitted after if they reopen prosecution and just confirm the patentability of the claims. Or the patent holder can amend the claims in a manner that doesn't really help you with whatever your potential infringement issue might have been, but now bulletproofs them or strengthens them because your prior art has been considered and dealt with. So those are some of the big drawbacks of ex parte reexamination. Now, if that happens, you can still in court rely on that prior art. There is no estoppel in a subsequent court case if you want to challenge the patent based on the same prior art or the same arguments. If you had it in an ex parte reexam, there is estoppel for some of the other procedures. But still, even without formal estoppel, the patent owner is going to be able to say, look, the Patent Office considered this prior art, they considered these arguments, and they deemed them to have no merit, and they confirmed the patentability of the claims over them. And so, you can really weaken your position if the Patent Office doesn't agree with you on how important this prior art is. So those are the pros and cons of ex parte reexamination. Next, we'll talk about IPRs and PGRs. I hope that helps to keep you out of trouble, and I hope to see you here soon.